statement, opening statement, Ms. Sala?
Yes, Your Honor. Given that it's day 2, we normally don't do the
Yep.
statement, but I can still do it if you would like.
Why do you say we don't? It's not.
Yes, Your Honor.
Well,
I will proceed with the statement if you would allow me.
okay, please.
This appeal hearing is in regards to CA 012-2021 before Chief Justice Zaki Azmi, His Excellency Justice Shamlan Sawalehi, and Justice Robert French. The applicants are represented by ANOMA FCE lead counsel is Mr. Stephen Thompson KC. The respondents are represented by Clifford Chance LLP. Lead counsel is Ms. Annalise Day KC. Thank you, Your Honor.
Yes, Ms. Day. Your turn now to start. Okay.
Good afternoon, good morning to everybody. So today we come on to deal with our cross appeal. Obviously, the court only gets onto this if you decide that the limitation appeal succeeds. And obviously, some of the things that I'm saying today only proceed on the basis that we're wrong in terms of how you approach this appeal. So if you're with what my learned friend said yesterday in terms of rehearing or re-looking at this issue, then I seek to persuade you today why the judge fell into error in relation to the question of the loss. This, no doubt, is a topic that vexes most legal systems, which is where you have a shareholder in a company suffering the same loss. What should be the rights of the shareholders individually to recover what is also the company's loss? And I don't think there's little factual dispute between us that the loss that's claimed is the company's loss. What in essence the judge found was that because the company hadn't brought a claim, the shareholders could bring an individual claim. And we say that isn't grounded in Lebanese law. And I hope to show you that. One thing that may not be apparent from the judgment is that the judge below was very, very interested in and influenced by Marex. He, at the beginning of the hearing, pointed out that he very much favoured the minority judgment in Marex as a matter of policy. And we say, unfortunately, that then infected his thinking in terms of how he approached the question in relation to this issue. And he effectively decided what is the minority view in Marex. And we say he superimposed that onto Lebanese law. And I hope to show you why that is not actually Lebanese law. But can I start by showing you a couple of extracts from the transcript, just to show you, obviously I was at the hearing, I don't think anyone else here was, in terms of advocates or the court. But if we can look, please, at page 02907, so 02-907, and I hope to be able to use the electronic numbers today to speed things up. This is the transcripts bundle if anyone's working off hard copy. And it's day 1. It's pages 22 to 23 of the transcript. And if we can start, please, at line 18, we see the judge interrupted my submissions and said this, well, okay, I think in terms of intellectual analysis, the dissenting judgment in Marex is quite helpful in deciding the question of whether the shareholders suffer a loss and are they entitled to recover subject to questions of double recovery and the like. But I don't want to get into that at the moment. You are merely sketching out the broad features of your case. And then he goes on. And if you go over to line 12 on the next page. Sorry, actually line 8. He says one might start with the proposition that both the company and the shareholders have suffered some loss. And then you have to decide how you are going to deal with what might otherwise be double recovery. Anyway, I'm just letting you know that when we come to look at the question, even though it is to be decided by Lebanese law, under Lebanese law, when we come to decide the question of whether there was a loss suffered by the shareholders, even though the company may have also have suffered a loss, when we come to decide whether under Lebanese law the shareholder is entitled to compensation for that, I think the dissenting judgment in Marex is quite an interesting source of thought. And what we will see is that he then imposes the Marex dissenting judgment in terms of what he says the policy should be under Lebanese law. I will show you that is not actually the position under Lebanese law. And then again, a second passage, page 106 of day one. This is at 02-928 of case lines. And then if I want to look at lines 10 to 23, where he comes back to this point, he says, I appreciate that the way that the case is pleaded is as it's pleaded, and we see it is the loss between two sets of value. But you were putting to the witness something rather different. You were, I think, suggesting it's the same loss. What I am suggesting is, and this is where I do recommend the judgment of Lord Sales in Marex, there is no necessary equivalence of the damage suffered by a company and the impact on the value of shares. So in general circumstances, the value of the shares will depend on what a willing purchaser is prepared to pay for them. That is not necessarily equivalent to the damage to the company's balance sheet. I am just making that point to you. So as I say, that doesn't really come across in the judgment, but we can see that the judge really came out from the beginning of this case when we opened it orally, very, very strongly expressing his views that the minority judgment, and in particular the judgment of Lord Sales in Marex, was the correct way to approach this question. So can I take the court just to look at the loss that's pleaded and the way in which that's put, because that is important for the purpose of this appeal. And the pleaded case you will find in bundle 1A. It's page 265 in the hard copy bundle. In the case lines, it should be 02-273. And I want to start by looking at paragraph 310, please. And at paragraph 310, we see it is alleged there that Deloitte failed to discover and report upon the alleged wrongdoing in which LCB was involved. It then goes on to say that if Deloitte had discovered and reported upon that wrongdoing, LCB would have been subject to, it's in the last line, regulatory intervention, which would have resulted in reforms and the recovery of alleged losses. Alternatively, if we turn back to page 304 of the pleading, you will see that there's an alternative plea that the same result. Sorry, it's 02-272. And it's paragraph 304. There's a second plea there that says that the claimants would have sought to secure minority shareholder relief and the removal of LCB's management. So the case is put in those two ways. Then it is alleged, if we go to paragraph 311, which is on 02-273, 265 of the PDF, that because Deloitte didn't report and discover the alleged wrongdoing, the wrongdoing was allowed to continue, and you will see there what's set out. So the first loss claimed is that LCB continued to incur losses from what is alleged to be imprudent related party transactions. Secondly, that LCB continued to engage in alleged money laundering, the effect of which was to prevent LCB from being able to undertake any international banking transactions, which is said to have effectively put LCB out of business. That you will see is actually at 159 of the pleading. We don't need to turn back to that. And then what's said is, as a result of that being put out of business by the FinCEN notice, the management of the bank took the decision to sell LCB's assets and liabilities to Société Générale and to place LCB into liquidation. That you will see is at 159. If you turn back in the bundle, it should be at 02-237 of case lines. Apologies for jumping around. This isn't the easiest pleading to negotiate your way around. But you will see there, penultimate sentence, the FinCEN finding effectively put LCB out of business. This resulted swiftly in the decision by LCB's management to sell LCB's assets and liabilities. Then if we go back to paragraph 314, subparagraph 2, which should be at 02-274 of the case lines. It should be 266 of the hard copy. What's then asserted is at 314 spot 2, LCB's assets and liabilities would not have been sold to SocGen and LCB would have continued to operate and grow. That's the next paragraph. And then we come on to paragraphs 315 and 316, which are the key paragraphs in relation to the nature of the loss and damage claimed by the claimants. And we see that what they claim is that therefore they would have retained a valuable shareholding in LCB as an operational bank, and secondly, continued to receive dividends after the date of the liquidation. And therefore at 316, the loss and damage claimed is the difference between, first of all, the sums that the claimants did in fact receive following the liquidation of LCB, and B, the value of their shareholding and the sums that they would have received but for the allegations made against Deloitte. Very important to note that the only alleged loss claimed is the difference between actual value of shares following liquidation and the value that those shares would have had if LCB had not gone into liquidation, but to use the claimant's words, had continued to operate and grow. So there is no dispute that all that's claimed here is an alleged diminution in the value of the claimant's shareholding in LCB. And that is a classic case of this not being an individual shareholder loss, but one that is the same loss as the company. There is no claim made for an alleged loss of opportunity to sell their shares. No case being put forward in that regard. And in certain parts of the transcript, the judge obviously floated what would be the position in relation to those claims. But in my submission, that's completely irrelevant because here there is no such claim made. There was no suggestion that it would be made. The claimants fairly and squarely pin their claim only on alleged diminution in the value of the shareholding in LCB.
That's versus a counterfactual shareholding, isn't it? What they would have been.
Yeah.
Which has some of the character of loss of opportunity about it, I suppose.
Well, yes and no, but obviously it's you could say that if an individual shareholder sells their shares, that might potentially have different losses for different shareholders depending at what time. Sorry, I think someone needs to mute there. Could you mute? I think the boardroom's unmuted, wherever the boardroom is. The point that I'm trying to really emphasize is everyone was agreed that this was the company's loss, that there was complete overlap between the shareholders' loss and the company's loss, because the claim here is founded on the value of the company, and therefore it cannot in any way be said that this is an individual loss. And the judge recognised that. We will see in the judgment.
I don't want. Sorry, my lord.
No, go ahead.
I just don't want Ms. Day to go off on a wrong footing. I don't think it's right to say everyone agreed that it was the same loss. Everyone agreed that there was a connection, but it wasn't agreed at any stage that it was the same or identical, and that's a distinction that might become important. So I don't want to interrupt Ms. Day there.
Well, I disagree with that. It was obviously Mr. Thompson didn't appear below, but there was no case made that this was a separate and distinct loss. And indeed, we can see that from the pleading. If that's not correct, no doubt you can be taken to submissions explaining why the pleading contains anything other than a completely a loss that is the company's loss. Now, the judge addresses this in his judgment, the issue of recoverability of that loss by an individual shareholder at paragraphs 126 to 151 of his judgment. I think, sorry, on the case lines, I'm obviously working off a hard copy of this. It should be 02-626. But I'm not entirely sure. And I want to start, please. He starts this section of the judgment at 126, but I want to look, please, at paragraph 139. Which is extremely important because he considers various matters, and then he goes on at 139 to say this, at this stage in this judgment, what in my view the defendants have established by one, reference to scholarly writings, two, judgments in decisions of the Beirut Court of First Instance and Bashara, and three, the evidence of Mr. Mattar, is that in the context of liability claims for management fault, there exist two rules whose reason is to avoid double compensation. Rule number one is that an individual, a shareholder cannot bring an individual claim for the diminution in the value of his shareholding where this is causally connected to loss suffered by the company due to management default. So there's no appeal against that finding by the claimants. So the finding of the judge, which is not under appeal and one that binds this court, is that under Lebanese law, a shareholder cannot bring an individual claim for the diminution in value of his shareholding where this is causally connected to loss suffered by the company due to management default. And then if we turn forward to paragraph 151, he then extends that and says that rule also applies to auditors. And he explains in paragraph 151 why that is. Again, there's no challenge to that finding of the judge as being representative of Lebanese law by the claimants. So this court must proceed in my submission on the basis that the judge has found, and it is not challenged, that a shareholder cannot bring an individual claim for the diminution in value of his shareholding, where this is causally connected to loss suffered by the company, including where that claim is made against auditors. And then if we turn back to paragraph 139.
Sorry, just on 151. He qualifies it by saying it's not necessary to make that finding, and that takes us back to 150, I think, doesn't it?
Correct. That's right. He found it obiter on his other findings, because what he goes on to say, as we'll see, is that if the company doesn't bring a claim, the individual shareholder can bring a claim. So strictly speaking, that part is obiter. But obviously, if you were to be with me that exception doesn't exist under Lebanese law, then it would apply. But that's why he says it doesn't arise, because he's already found this so-called exception, which I hope to show to you just doesn't exist.
Shaila, what's that video of CF guest is like he's in the supermarket? Can you take him off, please?
Yes, Your Honor.
CF
I'll remove
guest.
him from the meeting. Thank you.
Okay.
I'll do that, Your Honor.
Thank you.
We're taking
please
care of it. I
continue.
think.
Yes, Ms. Day, continue.
Yes, sorry, I just received a side message from somebody asking whether we've been hacked, but I think it's just one of the solicitors somewhere else. So hopefully it'll come off. Nothing so exciting.
He must be listening to the case while doing his shopping.
Yes. I can't imagine. It must be of great interest to somebody to hack in. But anyway, there we go. So that's what we've called rules number 1 and rules number 2 that the judge found in his judgment, and that binds this court. So you take it as Lebanese law that these 2 rules exist. And then if we go back to 139, we see what we've called rule 3. Could also be rule 2. That the second principle, fundamental principle of Lebanese law, is that where all the shareholders are damaged across the board by a management default, the claim for management default against directors must be brought as a corporate claim, ut universi, or by a derivative claim, ut singuli. So in other words, either these claims are brought by the company itself, or they are brought by the shareholders in the name of the company rather than by the shareholders in their personal capacity. And so you can see that there is no issue here of anything falling into a black hole. These claimants would have been able to bring this claim by way of an ut singuli claim. So in other words, by the shareholders in the name of the company. But instead, what they've sought to do is to bring this claim in their personal capacity. And in my submission, those rules are where the judge should have stopped, and the judge should have said, in this case, they've brought it in the wrong way. Because this is a loss suffered by all the shareholders, the fair and correct way would have been for this to be brought by way of derivative claim, but it hasn't. And in effect, the judge goes on to say that his decision is, and if we look forward at 148, we see this, paragraph 148 of the judgment. He says, as Professor Slim accepted, there has been no decision on whether a shareholder or group of shareholders can sue a wrongdoer who's caused damage to them and to the company where the company has declined to sue or is incapable of suing. Now, I say the reason there isn't a decision is because this isn't a principle of Lebanese law. The principle of Lebanese law is either the company sues or there's a derivative claim by the shareholders in the name of the company. So it's not surprising. And instead of using that to reach the conclusion, therefore, that this is brought in the wrong way, this claim, he then goes on to say the DIFC courts must therefore decide this question on the basis of jurisprudence and scholarly writing put before it, together with the views of the expert witnesses. And then he goes on to explain why, in his opinion, the claim should be possible. And I pause there and just draw to your attention that here he is citing no authority. He is not citing any basis for these views that he's expressing. And really what we see is a digression here into policy. Indeed, he starts little one with saying, in my opinion, the two rules are predicated on a risk of double compensation, and it is to be inevitably inferred there is no such risk in this case. He's not citing any basis for that. He's just saying that's his view. And second point, he doesn't actually have any basis that there's no risk of double compensation. There was no evidence before him that the company had been asked to bring this claim. There was no evidence that the other shareholders had been asked to join in this claim and had refused. This was simply an assumption that was made. Second reason, the shareholders have a claim for breach of duty owed to them and not just owed to LCB. That is, with respect, that doesn't help on the question of what loss is recoverable. That's simply saying they have a claim against the auditors.
So what he's saying is that rules 1 and 2 are not exhaustive, in a sense. There are factual circumstances where they won't apply, and this is where his exception comes in.
Yeah, but I mean, our point is that he's doing that from his own feeling as to his preference for the minority judgment in Marex. It's an extraordinary section of the judgment, this, because there is no reference back to any principles, any sections of Professor Slim's evidence, any of the scholarly writings, anything that would support this view. He has embarked upon his own principles, and I'm going through them because I want to show you that they don't actually stand up to scrutiny. So the first.
Sorry, sorry, I may be going ahead in terms of what you're going to say, but he seems to be falling back into the general application of Article 134. This is paragraph 148.
Yeah.
So there's this large principle. There are these two rules that he's found, but there's this large principle, and there's a circumstance where whatever underpins these principles, that's a double compensation principle, a double compensation policy, avoidance of double compensation, is not engaged because the company is never going to take the action. So therefore, the rug's pulled out from under those, the rationale for those two rules. So what do we fall back on? We look at 134. Isn't that the way he's sort of approaching it?
Yes, but he proceeds on the basis that no one has ever argued this in Lebanon before, which is a pretty odd starting point. I think that's the point that I'm making, that he establishes the underlying rules, which are correct, by reference to the cases, the scholars and the authorities. But he then goes on to launch into this section really without any basis in terms of having a basis in Lebanese law. It is correct in little 3, he refers there to Article 134, but of course you'd have full reparation with respect if you had a derivative action. But that's not the way in which this claim has been brought. So it's very important to bear in mind that it isn't just the claim by the company that is the remedy. The second remedy is to have a derivative action by all the shareholders where they're all joined in. And the judge forgets that when he comes to deal with this. Then little 4, he says it was open to other shareholders to bring claims for their own personal losses, but they've chosen not to sue. Again, the judge didn't have any evidence of this. This is a complete assumption that he made. For example, no evidence was put before him that the other shareholders had been asked to join in an action and had refused. There's just no evidence in relation to this. Secondly, Lebanese law actually recognizes the principle of equality among shareholders, under which all holders of shares of a particular class must enjoy the same rights and advantages. That's Article 110 of the Commercial Code, which is at 02-3675. So by going down this route, the judge was actually going against Article 110 of the Commercial Code. And that's why the authorities show that where the loss affects all shareholders equally, the claims must be brought by or on behalf of the company, so that the fruits of the claim are shared equally by all of the shareholders in proportion to their shareholding. So the judge here actually takes a route that's contrary to other provisions of Lebanese law. Reason number 5 was that the limitation period for the claimant's claim was unaffected by the claimants bringing their claim in light of LCB not bringing its own claim. We don't understand that. The limitation period is a separate issue to the issue of whether or not the claimed loss is recoverable. The next point was that justice does not require that the viability of a shareholder's claim for the diminution must be established once and for all at the time the limitation period begins to run in respect of their putative claim. We just don't understand that to support in any way the judge's finding that the exception exists under Lebanese law. In any event, insofar as it matters, this is exactly what justice does require, because if it were otherwise, shareholders would never know if they had a viable action. A company could bring a claim, it could discontinue it after the limitation period had passed, perhaps new management take over, and then leave the shareholders with no apparent claim. And what we say is that the viability of a shareholder's claim for damage can't depend on these sorts of chance issues. Point 7, he said it would be a grave denial of justice not to allow the claimants to bring their claim in circumstances where there's no risk to Deloitte of double indemnification. Again, that really is what my learned friend called yesterday circular reasoning. It's reasoning backwards from a sense of justice and fairness not being able to be done if the claimants can't bring their claim. Of course, they could have brought this claim in the name of the company as a derivative action, but they've chosen not to do so.
Sorry, Mr. Just ask you, what materials were before His Honour for the trial of the preliminary issues? There were the expert witnesses and the pleadings, and I presume there were some key documents. But was that as far as it went?
Yes, there were also agreed facts. So the parties agreed certain facts to be put before him.
So when you spoke earlier of I think what was said in Romans 4 and 148 about there was no evidence, that's it. It was either not pleaded or not agreed. In other words, there was nothing pleaded or agreed that would cover that proposition.
Correct. And I would start from the position that there was nothing in the pleading to say the reason that this claim is being brought by way of an individual claim is because we've asked the other shareholders, we've asked the company whether they want to bring this claim, and everyone else has refused to join with us or to bring the claim in that way. That's not pleaded, and in fact you would expect it to be in the pleading.
Yeah.
And
right.
and to be
when you're saying there was no evidence, it was essentially a trial on the pleadings and agreed facts
correct.
and evidence. Yeah.
Correct. And because it's not on the pleadings, in my submission, therefore, the pleaded claim doesn't set out a correct basis for this claim to be brought. And one of the difficulties with the route that the judge took is that you could have different claims being issued by different people. The reason that Lebanese law is as it is that you therefore have either the company bringing the claim or you have the shareholders collectively bringing the claim in the name of the company. The other point that I want to make here is that the judge overlooked some of the submissions that were made to him, that a shareholder, by subscribing for shares in a company, has accepted that his investment will follow the fortunes of the company. So where a company has a right of action, the shareholder can exercise such rights of control over its decision making as have been granted to him. And where the company's decision making organs decide not to pursue a claim, the shareholder obviously has to accept that, subject to remedies available to minority shareholders. But as I say, there was nothing pleaded, there was nothing put forward to suggest that these claimants have tried to get the other shareholders to bring a claim or had approached their rights as shareholders in any normal sense. And that's why we say would be the exact opposite of justice if the claimant minority shareholders can effectively bypass the majority decision in the way that the judge concluded that they could. This is a company that still exists. It's not disabled from bringing this claim, which is in other areas of law where sometimes courts have said it would be an injustice if individuals don't have claims because the company can never bring a claim. This is a company on which we have no evidence as to why it's not chosen to bring a claim. We have no evidence as to what the majority shareholders think of the claim, and therefore it is contrary to justice for these minority shareholders to be able to bring this claim in this way. Now, I want to go back and just look at the judgment as to how the judge said this would operate, because it's quite difficult to follow. If you can look, please, at paragraph 147. You will see there that this is where the judge tried to deal with the problem that you might therefore have competing claims. And you will see that Mr. Mattar had explained that the contention whether or not a shareholder can bring a claim must be determined at the time the claim arose, should not depend on the mere chance of whether the company intends to sue at a later date. And he points out, I put that to Professor Slim during the course of cross-examination. And this was the problem, that you'd never know what limitation period applied, you'd never know who was entitled to bring a claim or not bring a claim. And at the end of this paragraph, what the judge says, in effect, going back to what Professor Slim says, is that if the company changed its mind and decided to sue, the judge would take into account the principle of full compensation, and he would subtract or add compensation depending on the situation. Now, there is not a single case, not a single scholarly writing in Lebanon that supports that. It's not even clear under what power the Lebanese judge would be acting. It's completely vague. If we go back to 130 of the judgment, another vague statement. It's about halfway through, or 2/3 of the way through. You will see that the judge there said, well, you deal with double recovery, that can be dealt with by the Lebanese courts under the procedures available to them. Now, he doesn't identify what procedures he's talking about, what rules would allow the judge to do that. We've set out in our skeleton arguments 4 reasons why the judgment was wrong, and I want to just go through each of those in turn. The first is we say that his analysis was internally inconsistent, because if you look back to what he decides at paragraph 139.
What page would that be, Ms. Day? 02?
It's 139 of the judgment, which is 02-626.
Oh, 139. Okay, okay. You're
Yeah,
going to 139. Paragraph 139.
I'm going back,
okay,
yeah.
Okay, that's okay. Yes, go ahead.
So we see at 139, as I've shown you, the judge setting out that the shareholders cannot claim for the fall in share value, which is causally connected to loss suffered by the company due to management order to default. But obviously he then goes on to say that the effect of the exception is that the shareholders can, and indeed must be able to claim for that fall in share value, because in his words, that's what, quotes, full compensation requires. And in my submission, that means that the exception deprives rules 1 and 2 of any import, because its effect is that shareholders can bring a claim in all circumstances, subject only to some kind of procedural limit on double compensation that I've just taken you to, these vague procedures, the adding and subtracting in relation to compensation. Now, of course, I'm sure we're all familiar with situations where other legal systems have sought to grapple with the situation where a company is disabled, for example, from bringing a claim, those types of situations. That's not what the judge was talking about here. The exception that the judge found, without any basis, was that the shareholders could bring a claim in all circumstances. The only barrier on that was this issue of double compensation, including that you could have multiple claims with adding and subtracting going on. That is not Lebanese law. The judge, in fact, himself recognised, it's at paragraph 130 of the judgment, if we go back 02-621. Within that paragraph, it's the first sentence. The loss suffered by a shareholder is very different from the nature of a loss suffered by the company. So, as I say, this shows that he is creating this exception that means that the shareholder can sue in any circumstance. Second reason that the judge was wrong is that there was no basis in any authorities before the judge to find the exception, and he was plainly wrong to do so. He was absolutely right to find rules 1 to 3 are part of Lebanese law, and we see within paragraph 139 he cites at length the authorities relied upon. So absolutely right, no dispute, that is Lebanese law. He cites the authorities that he was taken to at length in his judgment. They start at paragraph 84 and they run through to 125. I'm not going to go through all of them. I'm going to go through some of them with you just to show you. But in effect, from those authorities, two propositions are absolutely clear. First, where a shareholder suffers a fall in the value of his shares, which results from loss suffered by a company in consequence of wrongdoing done to it, only the company may bring a claim against the defendant, whether that's the company itself or the shareholders in the name of the company. The corollary of that is that where the shareholder has suffered damage which is separate and distinct from damage suffered by the company, the shareholder may bring a claim against the defendant to recover that, but only that damage. And we've set out in our submissions, I'm not going to take you to it now, that those two propositions were common ground between Professor Slim and Mr. Matar. And that's why what you find in the literature, the authorities and the expert reports is this distinction of an individual claim by a shareholder for what's called personal damage. And it's individual and personal in the sense that those claims seek redress in respect of damage caused to an individual shareholder who's brought the claim, as opposed to the general body of all shareholders. I'd like then just to take you to a couple of the cases, the authorities that the judge was taken to. If we start, please, at paragraph 83 of the judgment, it should be 02-602 in the electronic bundle. And we go back to Nassif. You'll remember from yesterday, he's a former judge in Lebanon, and he's written a treatise on commercial companies. And he discusses this exact question. He says, what would be the rule where the behaviour attributed to the members of the board causes a damage at the same time to the company and to the shareholders? Should the company in such a case be considered as the only possible claimant, or should it be accepted that the company and the shareholders be equally allowed to bring a claim? And then the next sentence is crucial. The answer to this question depends on the nature of the damage suffered by the shareholder. Where the damage is separate and independent of the damage suffered by the company, both the shareholder and the company have the right to bring their claim because each seeks to get a compensation for the damage it suffered from. And then the compensation of the damage that affected one of them does not lead to compensate the damage suffered by the other one. Therefore, it must be accepted that each of the shareholder and the company has a proper claim. Each of the two claims is brought independently. And then these words, the shareholder brings his individual claim and the company brings the company's claim. So that's reiterating this distinction that you have individual claims for separate and distinct damage to individual shareholders, but where it is damage that affects all shareholders, such as a diminution in the fall of the value of the company, that is something that is the company's claim. And that can be brought either by the company itself or by all shareholders in the name of the company. And then we have the passage that follows that the judge has put in italics. However, the damage could affect the company, such as where the mismanagement leads to a decrease in its monies and the shareholder suffers therefrom indirectly because the decrease in the company's money affects the company's investments and subsequently the amount of dividends that he expects to receive annually and affects the share in the company's assets at the time of its liquidation. In such a case, the shareholder has no individual claim in addition to the company's claim because the compensation of the company's damage and the restoration of its capital to its initial situation lead to the exclusion of the shareholder's complaint. So that is saying in terms that the situation, the loss that's claimed here, which is the loss in italics, is not recoverable by the shareholders individually. Then if we go forward to 87, and that should be 02-604 for those following electronically. This is an extract from Kosian and Viandier, another authoritative text referred to by both of the experts. And again, you will see there that it's actually been set out that the partner who invokes depreciation of the value of his shares due to bad management of the managers does not characterize some individual damage that's different from the company's damage. The first is only the corollary of the second, Hence, the demand for compensation must take the path of the derivative lawsuit. So that is showing in terms. So when Mr. Thompson interrupted me and said it wasn't agreed, with respect, that is set out in the authoritative text, that what is claimed here is not individual damage, different from the company's damage under Lebanese law. It's a corollary, and hence you must claim compensation via a derivative lawsuit. And then again, we see at the end of that, the criminal chamber adopts the same approach. When the lawsuit for compensation takes the path of the civil lawsuit, the partner who indicates that the management faults of the manager of a civil company have led to a reduction in the amount of distributed profits does not invoke the compensation of some damage that's personal to him. So simply reiterating that the type of loss claimed here is not seen under Lebanese law as being individual loss, it's seen as being the company's loss. And we see in the paragraph below that Professor Slim accepted this was the view of the authors. He then tries to distinguish it on a number of grounds, none of which are sustainable. Firstly, he said it concerned directors rather than auditors. That doesn't matter now in light of the judge's finding at 150, which is not suggested to be incorrect. The judge found that under Lebanese law, the rules that apply to directors also apply to auditors. Secondly, Professor Slim attempted to draw what we say is an obscure distinction between a reduction in share value, which is a consequence of damage suffered by the company, and a reduction in share value, which is a corollary. That just doesn't make any sense. And in fact, when you read the Kosian and Viandier passage, we see that those mean the same thing.
I'm just wondering about, I can imagine where you have a diminution in the value of a company. So, effectively its capital value is less, and therefore the value attributed to each share by reference to the capital value is less. But shares are tradable, and there may be other factors affecting the valuation of shares. For example, reputational factors affecting the company that cast the shares in a negative light in the marketplace. So you could distinguish, whereas the actual underlying value of the company remains the same. So you could distinguish a diminution in the value of the shares from a diminution in the value of the company attributable to somebody's conduct, some misconduct or otherwise, or maybe actionable conduct. The way you took us through the pleading earlier, but is the way the case is pleaded one that clearly links diminution in the value of the company to diminution in the value of the shares uniquely? Sorry, I put that wrongly. I put the other way around. Is the diminution in the value of the shares the kind of uniquely linked to diminution in the value of the company?
I think so. Let me just check the pleading before I. Sorry, I've just.
There was a kind of.
I mean, yeah. The pleading, on the pleading, we say it's absolutely linked because 315 and 316 of the pleading are that they would have retained a valuable shareholding and they would have continued to receive dividends after the date of liquidation. So their first claim is that the difference between what they did in fact receive and stand to receive following the liquidation and their value of the shareholding in LCB and the sums they would have received. So that is completely contingent on the company. So there is no separate identifiable loss anywhere.
The counterfactual that we discussed earlier is linked to the value of the company in terms of its capital, etc., under the counterfactual circumstances.
Yeah. Correct. Absolutely. So although it's pleaded as value of their shareholding, it's actually the value of the company, because the shareholding only comes from the value of the company. And that's really what Kosian and Viandia, the point that we've been looking at. It says in terms, where you have a situation that leads to reduction in the amount of distributed profits, that is not personal damage. Let's then look at another authority that the judge was taken to that's in his judgment. It's paragraph 88, so it's 02-604. This is Lefebvre, and this sets out, it's at the bottom of the judgment on this page, that an action by a shareholder against the company is inadmissible as he claims for the loss of the value of his securities, a damage that is simply the corollary caused to the company and does not have any personal aspect. Therefore, the reduction of the company's patrimony could not constitute a damage for which the shareholder may claim compensation from the manager. A partner may not claim compensation for the loss of the values of his securities, regardless of the reason for such damage, e.g. downfall of the company voluntarily caused by the manager or deliberate reduction of the activity for the benefit of a third-party company. So again, in terms, saying that the loss claimed in this action is not claimable. And there was an extraordinary passage in Professor Slim's evidence in relation to this. He had a great deal of difficulty with this passage, and what he said in evidence, it's at day 1, page 60, lines 13 to 16, was that he didn't know who wrote this book as opposed to who published it, which in my submission shows somebody on the edge of being able to deal with it. The book in question is a respected reference book on French legislation. It has a digest of decided cases on company law, edited by French academics and lawyers, and it's frequently cited in the courts of France and Lebanon. And I say that was a very telling passage of evidence, because in a sense, this situation, this issue of whether this claim should have been brought in the name of the company is so clear. There are, and we're going to go through more of them, there are reams and reams and reams of writings in Lebanon which support the proposition that these shareholders cannot bring this claim. Let's go on to another one. It's paragraph 89. This was Maitre Corbaoui's report for earlier proceedings, and he actually cited Lefebvre, so the very passage that Professor Slim sought to minimise. It's 02-605 if you're looking at it online, cited in the judgment. His view said the Lebanese courts do not consider that the shareholders have an individual claim in the event of loss of value of their shares if the assets of the company are diminished. So he cited Lefebvre, and his view was that the Lebanese courts didn't see an individual claim as being possible. Then we go on to paragraph 90, Fabia and Safia. It's 02-605 again, following online. And this actually has a heading, lawsuit for individual damage. This lawsuit differs from that which was the subject of the comments above, in that it seeks to compensate the damage that is caused by the acts of one or more directors, not to the company or to all the shareholders, but to one or more shareholders individually for specific interests that are distinct from the corporate interest. And then there are some examples given of what that might involve. So you might have a case of improper retention of securities or dividends accruing to one or more shareholders. that would be an individual loss because that's only suffered by those specific shareholders. Or in case of violation of their preferential subscription right to capital increase, again, that's going to affect them individually. Or of false advertising having determined subscriptions or purchases. Not this case. Then we go on to TAHA, which is in paragraph 91. And again, that sets out that there will be an individual claim where the actions of the board of directors cause personal harm to one of the shareholders. And again, they give some examples. The board of directors refrains from giving a shareholder his share in profits. The board does not return to the shareholder his share upon expiry of the company, or issued a statement in which it gives a wrong representation of the company's position, enticing such shareholder to bring its shares and then decreasing its value. In such or similar cases, the damage occurs to the shareholder alone and not to the company. So again, more examples, really the same examples of what individual damage might be. Then 92, Kozian Viandia, again, damage is individual when it's personally suffered by a shareholder without being the consequence of some damage suffered by the company. The hypothesis is relatively rare. And that we say is absolutely correct. Then if we look at Kozian and, sorry, look at Merle is the next one at paragraph 94. And that, again, talking about individual lawsuit. And if you look at the last sentence in the first paragraph, the damage must be personal and independent of the damage that the company might have suffered, so much that in practice, the individual lawsuit is quite rare. And then there was one final reference that I want to take you to. It isn't in the judgment, but it's something that Professor Slim said, sought to rely on at one point, and I want to show you why it supports exactly the same principles as we've been going through. You will find it at 02-2466, it's Repair and Roblo. And we can see.
Please repeat the page again. I missed that. Sorry.
02-2466. It's 5C-2386 in the hard copy if anyone's using that. But you will see there that that sets out that a shareholder can initiate a lawsuit where you have personal damage, again setting out this is rare for a shareholder to do this. He must indeed establish that he has suffered personal damage from the improper act of the administrator. Then I want to take you to a case that was referred to. This is a decision of the Beirut Court of First Instance on the 23rd of February. It's at 5C-2414. You'll also find it at 02-2494. And this was a case in which a shareholder in a company that ran a restaurant brought proceedings against the defendant, who was a member of the company's board. And the claimant there alleged that as a result of the defendant's mismanagement, the company sustained huge losses, which ultimately led to its collapse. And he sought compensation for the losses sustained by the company, but he brought this as an individual claim, not as a derivative action on behalf of the company. And the court dismissed the claim. If we look, sorry. Yeah. If we can look, it's 2421 in the hard copy. Apologies, I'm not sure what number it is in the. I think it may be 202-2421. I'm not sure if that's this bit. Sorry, if you let me know if you have it. It's 2421 in the hard copy. I have a reference, it's 022421 as well in the soft copy, but I'm not sure that's right. It should be a page that starts at the top saying, whereas the distinction between the corporate action and the individual action.
No.
02-2501.
Thank you, I'm grateful.
2501.
Yeah. So this is the court explaining why it's dismissing the claim. And we see there set out at the top, whereas the distinction between the corporate action and the individual action lies in the nature of the claimed damage. So that's reiterating all the principles we've just seen, whereby if damage is general and occurs to the whole company and all of the shareholders, then the action brought by the shareholder would be a corporate action. But if damage is individual and occurs to only one or some of the shareholders and their assets, which are represented by the shares of the company, then the action would be individual. And you will see that there, that's an example of the Lebanese court citing Taha, the scholarly writing. So I think yesterday it was suggested that the court just divines these principles from the code. That's not how Lebanese courts operate. They do pay great regard to the writings of the scholars, and this is an example I wanted to show you of that being done, where Taha is being cited. And then he sets out that in this case the plaintiff requests compensation for the damage resulting from the closing of the business establishment owned by the company and from the request of declaring the bankruptcy. And then the court sets out that damage requested to be compensated is a general damage that occurs to the whole company and all of the shareholders, and consequently the action brought by the plaintiff is a corporate action. And that case is completely the same as ours, that what is being brought here is under Lebanese law a corporate action that should be brought by way of derivative claim, not in the way that it's being brought. Should be an action in the name of the company. The court doesn't say, well, but the company hasn't brought a claim, so therefore the individual shareholders can claim. The court says that it can only be brought by itself or by a shareholder under a derivative action. And the test set out in that case between individual and corporate damage is whether the damage is individual and occurs to only one or some of the shareholders. So that just shows you the wealth of authority. Sorry,
today. Was that issue the question of the incapacity or unwillingness of the company itself to take action agitated in the Bari case?
It's not referred to, but the point is that the company in that situation hadn't brought a claim. So if this was a principle of Lebanese law, you would expect to see it somewhere mentioned in the plethora of the scholars that I've taken you to, and indeed in this case, because if this is a principle of Lebanese law, then it would have been run in this case to say, well, that might be so, but because the company hasn't brought a claim, I can bring an individual claim.
We don't know whether the argument was agitated.
No, I don't think we can tell from the judgment.
Okay.
But I do say, my lord, it's absolutely inconceivable that there wouldn't be mention somewhere within this, as I say, wealth of authority, wealth of scholarly writing, wealth of talent at the Lebanese bar. Why has no one in Lebanon ever made this argument if this is the law? And you will have seen from the judgment that the judge and Professor Slim accepted it's never been sought to be argued. And I say that's for good reason, because there is a route to bringing this claim, which is the derivative action route in the name of the company by all the shareholders. It's just in this case, unfortunately, the claimants have sought to bring it by the wrong route under Lebanese law. So in light of all of those authorities, we say that the judge shouldn't have accepted the evidence of Professor Slim, which was that the Lebanese law distinguishes between individual and corporate claims because of the principle of double recovery, and gone on to find this exception which completely obliterates the rule itself. I've taken you through the judgment already at paragraph 144, but we say that's absolutely striking for its lack of reference to any authority or any principle. And I've taken you through why many of those reasons are inconsistent with other provisions of Lebanese law, in particular Article 110 of the Code of Commerce, which sets out in terms that Lebanese law represents a principle of equality among shareholders. So all holders of shares of a particular class should enjoy the same rights and advantages. I've also drawn to your attention the deeply problematic reliance on so-called Lebanese procedures in inverted commas. The judgment does not identify anywhere what procedures those are, how they might be justified. The only thing we get is paragraph 147 of the judgment that I took you to, where he says that a Lebanese judge would subtract or add compensation depending on the situation. Absolutely no basis for saying that. So we say the judge was, with respect, plainly wrong. He reached a decision that was outside the range of proper judicial conclusions open to him. And we say you should apply this wealth of authority and set out the rule that the judge found, but to say that there was no proper basis for him finding this exception. And therefore, this claim can only be brought by way of derivative claim. So unless there's anything else I can assist you with, those are my submissions.
Okay, any question from the judges? Can we take, say, a 15-20 minutes break? You don't mind, judges? Okay. I'll pause. I'll mute.
So sorry, the Chief Justice muted a little bit earlier than telling us what time we'd come back.
About 15-20 minutes. Say what now is what time are you? I have here 5:15. 5:15. Okay. Say 5:35. 20 minutes. Is that good enough for you to get a cup of coffee?
Yes, thank you.
You want half an hour? Fine with me.
All right.
Okay. I'll come back. I'm going to mute and then remove my video, but I'll leave the link here.
Thank you.
Since parties and judges are already here, we might as well, if you don't mind. Okay, Mr. Thompson.
Yes, thank you, my lord. So just a few preliminary points, and then I will give you a roadmap of what I intend to say in answer to this. Firstly, right at the beginning of her submissions, Ms. Day made a comment about the approach you might be taking to this appeal. You obviously heard submissions about that yesterday, and you know our respective positions. It seems as if Ms. Day is saying that only if I am right about what I said yesterday ought you to hear what she said today. That seems to be what she's saying, and I can understand why she might be saying that for tactical reasons. I will be taking the same approach on both days. In my submission, it is the same rule which applies, and you can approach this as a question of effectively Lebanese law, or under the international approach, or in the further alternative under the English approach, which obviously treats foreign law as a special fact. More to the point, on this case, and I will demonstrate this by reference to what the judge actually wrote, on this case, it is absolutely clear that on this issue, and only on this issue, the judge did actually engage fully with all the arguments and evidence, call it what you will, about Lebanese law, and did express coherent, reasoned explanations for the conclusions he came to. And when you read it from start to finish, as opposed to jumping around, you can see the coherence of what he's saying. I with all due respect to the judge, it is in places a little dense, but it is perfectly coherent. The other introductory point I wanted to make is that we are obviously engaged in points of foreign law, and it's foreign law of a relatively small jurisdiction. I looked it up. Lebanon has a population of just under 6 million people, somewhat smaller than London, half the size of UAE. It's not usually surprising then that in that country of that size, which probably has even fewer as a proportion of lawyers than England, certainly than the US, that not all possible questions of company or any law have actually been worked out. It's telling that the whole concept of reflective loss was only something which in English law was even dreamt up in the 80s, a good 100 years, even taking it generously, after company law was originally developed in English law. So the position is that if you are, as a judge, required to consider as a matter of expert foreign law what the highest court in a particular jurisdiction would decide about a point, and if there has been no decision on that point, and if as well there is little learning which focuses on the point, nevertheless you have to come to a decision. You have to use your forensic and judicial skills to decide, in the light of the principles which do exist, what the highest court would decide. That is a requirement, obviously, which fell upon the judge. In my respectful submission, he did that admirably, and there is no doubt, and I don't think Ms. Day and I disagree, there is no doubt that there is a limit to the assistance which he can get from the primary materials, the case law and the scholarly writings. Nevertheless, for reasons he explains, he came to his conclusions. What he did, and I'll put it at the highest level before descending to the detail, what he did was to think about, firstly, the general principles which were common ground, the general principles in the area of law which the parties agreed upon. Secondly, to identify whether there were any restrictions, relevant restrictions on those general principles. And then thirdly, to consider the ambit and the scope of those restrictions. It is, with all due respect to Ms. Day, erroneous and misleading for her to describe things as rules and exceptions and exceptions to exceptions. What he did, and I will demonstrate this by reference to his judgment, was very clear. Accepted general principles, rules which limit the general principles, the extent of those rules. I will then, I'm afraid, the way I'm going to do my submission, at the risk of taking over ground you've already seen, is to look more closely at the judgment from beginning to end on these points. It starts at paragraph 126, and it goes, as you know, to paragraph 151. It's at page 52 of the judgment. Could, if any of your lordships require a page number other than that of the judgment, or paragraphs other than the judgment, please say now, because what I intend to do is use the judgment paragraphs and judgment page as I go through. So 126 identifies the question, 127 explains his approach is going to be one considering the matter as principle without the defendant's arguments at all. And 128 explains his approach. So 129 is where he starts the heart of the analysis. And what he does in 129 is to identify the general principles which are common ground. And he says there are, on its face, Article 178 does not limit the entitlement to sue an auditor for supervisory fault to a claim brought by a company, ut universi, or a derivative claim brought by shareholders, ut singuli, on behalf of the company. So there is no express limit in 178 to the entitlement to sue. And he points out in the second sentence that Mr. Matar had accepted that a shareholder could bring a claim under 178. So far, he has said there is no limit to the entitlement to a shareholder bringing a claim for supervisory fault against a company on those bases. Then he says it's common ground. This is 2 lines from the end of the page. It's common ground that to establish the necessary supervisory fault, a shareholder must establish a breach of duty owed to him or her that's caused him or her individual loss. Now, that was the general principle of DELITTE that we looked at yesterday, and the judge refers to Articles 122, 123 of the LCOC that we looked at yesterday. The general principle is if you have fault and you have loss and they're causally connected, there will be that will be an establishment of the right to claim. He then goes on to say that there is a general principle which is accepted, that there is a principle of full recovery. He does that by reference to what Mr. Matar says, but he also says in 130 very clearly that there is an obvious distinction between the loss suffered by a company and the loss suffered by a shareholder. Now, Miss Day said wrongly that this was common ground below. It was not common ground below. It was that's what the claimant said. The defendant said the losses were the same. As Miss Day still says, she is wrong to put words in my mouth or the judge's mouth, and I can make good that point most easily simply by looking at the judgment. If you look at the judgment itself at the bottom of this page, 53, you can see that the judge quotes the cross-examination of Mr. Matar. I'll read it out in full because it's very important. This was Mr. Fisher's question. Mr. Matar, I'm not putting to you anything about priority. I simply wanted to establish 2 things, really, which I think we are agreed upon. That the nature of the loss suffered by the company and the nature of the loss of a shareholder, whilst they are related, are different. That's the first thing. So that puts paid to Miss Day's idea that it was common ground. The second thing, which I think we've agreed upon, is that in both instances, those losses could be recoverable in principle in Lebanese law, provided the losses are causally connected with the wrongdoing that's caused them harm. That's the DELITTE point. Answer, yes. Over the page, the next question is, I would suggest that there's no risk of double recovery that cannot be dealt with in the courts. For example, the courts in Lebanon would have a residual power to decline to make an award in appropriate circumstances if they thought there was double recovery. And there are procedural rules. Certainly we have procedural rules in the common law for joining parties, so parties could be joined to an action. There are various mechanisms that could be used and are recognised in Lebanese law to prevent any concern about double recovery. Yes, there are. So that puts paid to Ms. Day's other point that there was no suggestion or evidence or indication that Lebanese law had procedural rules to cope with the risk of double recovery. That came from Maitre Matar's own mouth. In fact, if you want it, there is express and clear reference in the closing submissions of the claimant, which makes this point good. If we go into the bundle itself and look at page 02745 of case lines, that's 02745 of case lines, which is page 721 of the bundle, of the PDF bundle. This is the written submissions of the claimants at the end of the trial, and under the heading distinct loss, the claimant said this: the cross-examination on Professor Slim revealed the defendant's misconception that loss suffered by the company and loss suffered by the shareholders is the same. Ms. Day asked Professor Slim, the company suffers a loss in the value of the shares, doesn't it? Yes. The shareholders suffer a loss in the value of their shares, don't they? That, of course, is not correct. The company does not own its shares, so the loss of the value of the shares is not a loss that the company suffers. The company may suffer detriment to its business and assets, which it does own, but that is not the same as the loss of the shares. And that is the point that was taken up by Mr. Fisher in cross-examination of Mr. Matter. So far from it being common ground, it was quite clear from the submissions given to the judge that it wasn't common ground, and it's quite clear that, in fact, Mr. Maitre Matter, when pressed, accepted the claimant's position. It is unsurprising then that in paragraph 130 of the judgment, the judge says this: in my judgment, it is manifest that in the absence of some special rule, the loss suffered by a shareholder when the value of his or her shareholding in a company is diminished in consequence of damage suffered by a company is very different in nature from the loss suffered by the company, even though there may be a causal connection between the two. That's because, in the ordinary way, the value of a shareholder's shares depends on what a willing purchaser would have paid for them pre and post the occurrence of the damage, either through a bargain on a stock exchange where the shares are listed or by private treaty. The damage suffered by the company will be the adverse impact on its assets and its opportunity to trade profitably, which are the interests of a quite different nature from the shares held by the shareholder. Further, as accepted in cross-examination by Maitre Matter, any problems with double recovery caused by the shareholder and the company, each recovering in respect of their pleaded losses, could be dealt with by the Lebanese courts under the procedures available to them. So not only was this a live issue on which submissions were made and evidence was taken and the experts were cross-examined, the judge has identified the distinction and made a reasoned conclusion as to why he agrees with the claimant. Now, it is obviously right that that line of thinking has also been engaged in cases like Marex and indeed many others in the common law world. It is right to say also that Lord Sales, in his dissenting speech in Marex, engaged with this in some detail. It is a very learned judgment in which he grapples with, at the highest level of principle, these sorts of questions. No doubt that's why Justice Field said he found it useful, but that isn't imposing it into Lebanese law, as Ms. Day put it. All it is identifying that there is this question of principle which exists whenever you have a limited liability company with shareholders, and then the judge taking the evidence about Lebanese law without any preconceptions and trying to work out what the position is there. And his answer, in my respectful submission, is unimpeachable. At paragraph 131, the judge then says he's going to turn to the principal scholarly writings and judgments relied upon by the defendants for their case, that where the company suffers loss which is causally linked, not the same, causally linked to loss suffered by shareholders in the form of diminution in the value of their shares, only the company or the shareholders representing the company can sue the party at fault. And this line is very important. In doing so, I'm concerned not only to identify the conditions therein laid down as to the claims that can be made, but also the underlying reasons for the conditions. So what he sets himself the task of looking through the materials to find whether there's support for the defendant's submission, and if there is, what the rationale for that support is, what the purpose and the underlying reasons for those conditions are. Now, this is where it's worth looking back to paragraph 19 of the judgment to remind ourselves what it was that the defendant said below were the two principles which were overarching freestanding principles. It's paragraphs 18 and 19 of the judgment, and it's page 14 of the judgment on the internal pages. And it's 19 really where the judge sets it out. The defendants argued that under principle 1, where a defendant commits a fault which causes loss to the company, the claim seeking redress from the defendant for that loss belongs to the company. Common lawyers would know that as the rule which was examined in Marex, that comes from, I've now forgotten the case, the 1950s case of Edwards and Halliwell. Now, but obviously we're not in the common law, so we shouldn't read too much into that. It's just the label we call it. The next sentence says, this rule contends that the defendants is derived from the company being a legal entity in its own right, separate from its shareholders, and 2, the specific rights conferred on shareholders by Article 105 of the Code of Commerce, such as the rights to vote at general meetings and to participate in distributions out of profits, and the principle of equality amongst shareholders derived from Article 110, which has been touched upon today, upon which all holders of the same class of shares enjoy the same rights and advantages, so that each shareholder's investment follows the fortune of the company. So that's the principle. The principle is set that out there in the first sentence, and that's the one that the judge refers to at paragraph 131. The judge then spends the next 3 paragraphs, looking at the underlying material to decide what it tells him. And he obviously finds greatest support and help from Elias Nassif's treatise on commercial companies, which you've been taken to. And he says there, it states that both the shareholder and the company can sue if the damage suffered by the shareholder is separate and independent of the damage suffered by the company, because the compensation for that damage that affected one of them does not lead to compensate the damage suffered by the other. In other words, as is clear from the italicized word in the document, while the principle is expressed in terms of the nature of the damage for which the shareholder can sue, its purpose is to avoid the shareholder achieving double recovery for his loss. On the one hand, receiving damages from the defendant, on the other hand, receiving the beneficial effect on the value of his shares where the company recovers damages for its loss. Obviously, that the principle of avoiding double recovery is one which any coherent, advanced judicial system should have. You should make sure that people aren't recompensed twice for the same loss, because they'd be in a better position than if they had not been wronged in the first place. That's extract A. He then says, the judge, 133, this principle that the shareholder can only sue for loss that is separate and independent of the damage suffered by the company is sometimes expressed in the scholarly writings and judgments in terms of individual damage and of the corollary of the damage to the company. But in substance, it's the same principle with the same raison d'etre that's articulated in document A. And the footnote there at 25 and 26 refer to what he calls capital B, C, E, G, and then B, C, and H. Those are the other extracts, with I think one exception, that Miss Day has taken you to today. It is right to say, I won't take you back to them all, that the others are shorter than the first one, and that the others don't have as much logical reasoning within them. It's the Nassif treatise which sets out and gives you an insight into the purpose of the rule. The others, like many of the scholarly writings we were looking at yesterday, simply state boldly what the rule is, which is not a great deal of assistance to a judge who is trying to determine the scope of a rule which hasn't actually been specifically addressed in the Lebanese courts itself. So he takes obviously greatest comfort from Nassif's treatise, but he says that the others are of a piece, and they are of a piece. He basically comes to the conclusion, I'm jumping ahead. So let's go on. In 134, he makes the point that this principle which he has identified in the learning is part of defendant's principle 1. And then he said another strand of this principle 1 advanced by the defendant in reliance on Maitre Matar's evidence is the view expressed in some of the writings and jurisprudence that if all the shareholders suffer damage across the board caused by management breach of duty, the claim must be brought by the company ut univici or by the shareholders in a derivative ut singuli claim, and not by an individual claim. It's to be noted at the outset that none of the scholarly writings or judgments relied on for this strand to principle 1 make any reference to the principle of shareholder equality. So this principle of shareholder equality, which was rolled out below and has been expounded on again today, is not something which can be identified in any of those writings. And the judge effectively rejects that as a basis or an extension of the strand of principle 1 that he's identified. And so he concludes in 135 that he is going to accept Professor Slim's view that the purpose of any distinction between a company claim and an individual personal claim is the avoidance of double compensation. In other words, just as the purpose of the rule that a shareholder cannot sue for the diminution of the value of his or her shareholding caused by damage to the company for which the company has a claim is to avoid double compensation, so too is the purpose of the rule that where damage is done to all shareholders, the claim has to be a corporate claim, ut singuli, or a derivative claim, ut universi. I think it's probably the other way around. I accept Professor Slim's evidence fortified as it is by the last paragraph of the extract from Elias, that there's no scope for a claim ut universi where a claim is made against auditors where all the shareholders across the board have suffered the same damage. So what the judge does, with, in my respectful submission, impeccable logic and care, is to identify the underlying rationale for the rule in order that he can go on, as he does in a moment, to consider the scope and ambit of this rule. That's principle 1. He comes back to summarize this, but that is the end of his analysis of principle 1 and the purpose of the rule. He has in effect accepted the core of principle 1. He then goes on to consider principle 2. Can you look back at paragraph 19, where principle 2 is first set out? It starts 4 lines from the end of the page in paragraph 19. It's page 14 of the judgment, the internal page number. And it says principle 2 is the principle of shareholder equality and provides that where, due to a breach of duty, a loss is suffered by the company which affects the shareholders, such as a diminution in the value of their shares, the claim for that loss must be brought by or on behalf of the company, so the fruits of the claim are shared equally by the shareholders in proportion to their shareholding. Now, that is a different principle from principle 1. It obviously has some related elements, but it is a different principle. And as the judge pointed out in paragraph 20, the rival contentions of the parties were actually similar to the judgments in Marix. Now, there's a very good reason for that. Well, there's at least one good reason for it. The reason for it is that these questions of principle about whether shareholders' loss and companies' loss are the same, whether they're separate, whether they're connected, and whether they can be recovered simultaneously are precisely the questions which had to be grappled with in Marix, and in which different judges of the highest court came to different conclusions in Marix. So they are, for reasons to do with the principled approach of company law, ones that have been dealt with in England, as it happens recently, in the UK recently. Going back to paragraph 136, we can look at what the judge says about principle 2. In summary, not to keep you in suspense, he rejects the idea of principle 2 on various bases. They're set out in 136 to 138. Turning to the defendant's principle 2, I can find no reference to Article 110 and or the claimed principle of shareholders' equality in the defendant's written opening submissions or in the writings and judgments that were put to Professor Slim in cross-examination. Further, it was not relied on by Maitre Matter when giving his reasons for his opinion that shareholders who suffer a diminution in the value of their shares in consequence of a loss connected to a loss suffered by a company cannot sue the wrongdoer who has caused these separate losses. Instead, the only reference Maitre Matter makes to Article 110 is in his second report, where he says in paragraph 57 that the prohibition against recognising a reduction in value of a shareholding alleged to have been suffered as a result of a company suffering loss adheres to the default position of equality amongst shareholders in their participation in the company. And then there is a reference in 137 to the cross-examination that Miss Day conducted of Professor Slim, which, with all respect to her, didn't get very far because the professor didn't accept the unfairness which Miss Day put to him halfway down the next page, and didn't accept the principle at all that there was some sort of equality, equality principle which lay through this. And the clearest point is that at the end of this question, the last question, the second last question Miss Day asked, so your position is that one shareholder can bring a claim and recover the entire loss caused to the company. Is that correct? No, my answer is that we have under Lebanese law a very important principle, which is the principle of full compensation. And this means that the injured, the aggrieved party must be compensated in full. It has no impoverishment, no enrichment. And if the shareholder has suffered a damage which is personal to the shareholder, and the company has suffered a damage which is personal to the company, the audio falls out, to avoid the compensation. And if the company is compensated, then the shareholders will not have the right to be compensated. But if the company is not compensated, then the shareholder has the right to be compensated on the ground of principle of full compensation. Question, but the shareholder cannot recover for the company's entire loss, can it? No. So the conclusion the judge draws at third paragraph 138 is that as this principle, given that the defendant's claim principle 2 was not advanced in the defendant's own written opening submissions and was not advanced by Maitre Matter, certainly not in his original report, and was not accepted by Professor Slim, and it's not in any of the scholarly writings or the judgments, and that it is therefore no more than an unsupported submission advanced by counsel, and he concludes that principle 2 is not established. That is, in my respectful submission, also completely unimpeachable. 139 is the paragraph that I think my friend started with, but it is in fact a pause that the judge puts into his judgment to draw together his conclusions at this point. I agree with her, it's important, but it's important to see the extent of his conclusions at this point. At this stage, the judge says, in this judgment, what in my view the defendants have established by reference to the scholarly writings and the judgments and the evidence of Mr. Matar is that in the context of liability claims for management fault under Article 168, a director claim, obviously, there exist two rules whose raison d'etre is to avoid double compensation. One, a shareholder cannot bring an individual claim for the diminution in the value of his or her shareholding where this is causally connected to loss suffered by the company due to management default. And pausing there, even if, as the judge explains, it is in fact qualitatively different, and everyone has accepted it is qualitatively different, he is saying, accepting the core of principle 1, that he agrees with the defendants that the shareholder cannot bring an individual claim for the diminution in value of the shareholding if it's causally connected to the loss suffered by the company due to management default. And this is why Ms. Day's submissions are slightly off the point, because all the learned scholarly writings that she took you to effectively say that, and the judge accepted that. It's not as if the judge was wrong. He wasn't even rejecting the point. He was accepting the point. The question that follows is, how wide does that principle go? He's not rejecting the principle, which is where Ms. Day, I think, has gone off on the tangent. The second thing the judge says he can conclude at this juncture, Roman 2, is this: where all the shareholders are damaged across the board by a management default, the claim for management fault against directors must be brought by as a corporate claim ut universi or by a derivative claim ut singuli. So that's what he's accepted so far of the defendant's case. The defendant went further, and he's rejected the stretch that was principle 2, and he's limited in his conclusions what he finds is the core of principle 1. He then asks himself at 140 in a paragraph which I have to say, at least on my reading, is a little bit dense and hard to follow. But effectively what he's saying in paragraph 140, and I'm going to paraphrase before reading it, is, do these rules then apply when a company has not brought and will not bring a claim against the wrongdoer? And do they apply against auditors? Because what he said in 139 is all about management default. So they're all really are tied back to the director's claims, Article 168. He then says, I need to think about it for auditors, and he says, I need to think about it in circumstances where the company isn't bringing the claim. And obviously that makes perfect sense in circumstances where he says that the rationale for this rule is to avoid double recovery. Now, we're now completely outside the scope of the thinking in Marex, because the majority in Marex, even the majority in Marex, we haven't got it in the bundle for some reason, but even the majority in Marex do not consider that the principle of double recovery is sufficient to justify the rule about reflective loss in English law. They say there are all kinds of other principled reasons. Lord S.A.L has his own views on it, but the point is nobody thinks in England that the double recovery rule is the basis for some rule against recovery in the hands of shareholders. So he is, whatever interest and help he found from the Marex decision, he is by paragraph 140 completely off-piste. He's just talking about Lebanese law. So in paragraph 141, however, what he refers to here is the defendant's contentions that are based on Marex. So 141 to 142 are effectively the logical reasons which were given by Lord Reid and Lord Hodge in Marex. They are in fact almost verbatim, some of them. I needn't take you through them, but it is, I was accused of this yesterday, but I think it's fair to say that the defendants here really have used a common law approach in their submissions on this point. And they are using in support of their contentions all the principles which found favour with the majority in Marex. But it isn't Marex, the majority or the minority, which governs the judge's rationale here, whatever interest he might have indicated at the beginning of the case when he was talking to Miss Day in her opening. Just on Marex, while we're on it, just to kill this point entirely, as I said, the whole idea of reflective loss was only first identified in English law in the Prudential case in, I think, 1981. And so it has only been around for some 40 years. It isn't shared by other judges, particularly Lord S.A.L, Lord Hitchin and Lady Hale, or indeed in the courts of New Zealand. It would be very interesting for those of us who take an interest in these things to see whether the minority decision in Marex is the one that is taken up by other courts in common law jurisdictions. It'd be interesting to see, for example, how Hong Kong or the BVI or Cayman might address it, or indeed, dare I say it, the DIFC. Of course, we're not actually engaged with the law of the DIFC at the moment. We're engaged with the law of Lebanon. So all of those points are only of academic interest to lawyers who might be interested in such a thing. They take the defendant nowhere at all. Now, he then goes on from paragraph 143 to go back and consider the expert evidence, the scholarly writings and the judgments which were put before him. And he summarises, and I needn't take you to what Professor Slim and Maitre Matar had said, but his conclusion on this point is in 148. So let's advance straight to 148. The first point to make, which is a point I made at the beginning of my submissions, is that everyone agreed that there was no decision on this point in Lebanon. As Professor Slim accepted, the judge says, there has been no decision on whether a shareholder or a group of shareholders can sue a wrongdoer who has caused damage to them and to the company, where the company has declined to sue or is incapable of suing. So, just be careful here, because what the judge has already said is there is a principle, which he has identified at 139, that the shareholder cannot sue in circumstances where there might be a risk of double recovery. That's 1391. And what he is now looking to see is whether that principle extends to the special case where the company itself is not going to sue or is incapable of suing. And again, we'll go through the logic, but I'll break the suspense. The judge says, I'm paraphrasing, if the purpose of a rule is to avoid double recovery and the company is not going to recover, the rule shouldn't be extended to those circumstances. It is a matter simply of logic that he comes to that in describing in explaining the ambit and the scope of this rule. He sets out there 7 reasons why, but the error that Miss Day makes in reading this paragraph is to find here, as she thinks she is doing, reasons why the judge has an exception to a rule. But that isn't what he's doing. What he is doing, as is absolutely clear from his wording, is considering whether the principle he has found at 139 ought to be so wide as to extend and exclude the general principles of Lebanese law in this special circumstance where the company has declined to sue and is incapable of suing. So actually, what his 7 comments in paragraph 148 are doing is pointing out that it would be completely unprincipled to expand this rule to that situation where the company isn't going to sue, given that the general principles of Lebanese law would, in any other circumstance, permit it.
So he's identifying the 2 rules. They rest upon a certain policy premise, which means they're non-exhaustive beyond that policy premise. And then he asks himself, is this what he's doing? He's asking himself the question, if a Lebanese court were asked about the case in which a company is unwilling or unable to sue, what would their answer be? And that's just an extrapolation because nobody's asked them. So he's not
exactly.
He's not determining what Lebanese law is. He's determining what he thinks it would be held to be by a court having appropriate jurisdiction in Lebanon, putatively the highest court in the land.
Well, with respect, my lord, I think those 2 things are the same. It is obviously an exercise of judgment, but then that is what the profession of judging involves. He is required to find what the highest court in Lebanon would decide. That's what we saw yesterday from Byers, and that is, and this may be somewhat of a legal fiction, but that is, at least as far as this case is concerned, a judicial finding in the DIFC of what Lebanese law is.
Yeah, well, I'm not sure that it can be fitted into that taxonomy. It seems to be a different kind of judgment. And no doubt that kind of judgment is required in many cases, or in other cases, yes, where one is determining the application of foreign law which has lacunae in it to a particular factual situation.
Yes, well, I mean, I dare say in almost any case that gets to a contested trial, because if it's obvious, the parties will presumably just be able to agree it. So generally speaking, when you do have contested foreign law issues before an English or any other court, the difficulty is that there might be some uncertainty or lacuna in the foreign law itself. I mean, we could imagine that if we were the foreign lawyers and someone else was trying to discern the ambit of let's imagine reflective loss in 2018, there might be some great difficulty in doing so. And so actually, but that doesn't change, I think, the fact that what the judge is doing when looking at foreign law is seeking to identify, by reference to whatever materials are given to him or her, what the foreign law is and how a foreign court at the highest level would decide that very issue. Now, obviously, the judge might be wrong. It might be that the Court of Cassation comes up with a decision next week which is completely wrong. But as far as the legal process is concerned in this court, this is what the judge has had to find for the purposes of this case going forward. There's no other way of doing it.
And the next time we have a case come up in this court involving Lebanese law and the Court of Cassation had come to a different view, then there'd be a different answer.
Well, yes, and that throws us back.
In any judgment, that's the foreign law.
Well, and it throws us back to the fascinating question that we were debating yesterday about the status of foreign law in this court, because obviously under the English approach, any decision made in this court about Lebanese law would be fact and therefore would have to be proven all over again tomorrow by some different claimant and defendant. But arguably, if this is a finding which your lordships uphold, obviously, then if it's a finding effectively of law, then if a parallel case is brought by somebody else tomorrow, they ought to be able to rely upon the finding. But I'm going slightly out with the scope of my instructions, but that seems to me the logical conclusion of the two different approaches we were debating yesterday, either which way the judge is entitled and indeed required to do this exercise. In any event, I don't know if that satisfactorily answered your Lord's question. I've maybe gone a little bit wider.
Oh no, it's just an interesting conceptual question as to the actual nature of the exercise we're engaged in here, and as I think I suggested yesterday, shoehorning it into fact is maybe a start, but I think we're engaged in a somewhat different exercise.
And as you know, in my submission, that is exactly right, and I would invite you as the court of final instance in the DIFC to draw some principles on this point in your judgment. But in my submission, the correct approach is, I think, as your lordship was suggesting to me yesterday, that this isn't and shouldn't be treated simply as questions of fact, but being questions of law, as all lawyers know we have to do. Sometimes we have to come to conclusions about what the highest court in our own or foreign jurisdiction might decide without having the clearest pointers and guidelines to what that would be. And there's an exercise of judgment and discretion in doing that. And that is what the judge did. And in my submission, he was required to do it. And here at 148, what he is doing, having identified a particular principle largely based on the defendant's own submissions, he is now considering whether that principle, given its premise, ought to be extended out to the peculiar situation where the company itself is not going to sue, which obviously has ramifications given the fact that the principle is itself based on the avoidance of double recovery. And that's, in my submission, how you have to read 148. The second sentence, I think, touches upon the issue that my Lord Justice French and I have just been debating. The DIFC courts must therefore decide this question on the basis of the jurisprudence and scholarly writing put before it, together with the views of the expert witnesses. But then the judge expresses his views. In my judgment, such a claim is possible, given that, one, in my principle, the two rules are predicated on the risk of double compensation. It's inevitably inferred that there is no such risk in this case. Now, pausing there, he has said, and he has set himself the task of finding what the purpose of the rules are, and he has concluded that they are to avoid the risk of double compensation. And he has found that conclusion on the basis of Nassif's treatise, which is the only document that was put before him which identified it, and on the basis of the questions and answers which were put to the expert witnesses before him. He says in the second half of that sub-paragraph, it's inevitably to be inferred that there's no such risk in this case, and that's obviously right. I mean, apart from anything else, the very people who are accused of the wrongdoing in this case are still in control of the company, even in liquidation. And the auditors who are being sued are still the auditors of the company in liquidation. He is absolutely right to infer that there is no risk of the company suing in this case. And certainly, if Ms. Day is right about her limitation periods, the company would be out of time to bring any claim. I think probably even on my case, the company would be out of time on most instances to bring his case. So that's the first point. Double compensation being the principle, there's no reason to extend it to that situation. Two, the shareholders have a claim for breach of duty owed to them and not just owed to LCB. That's the primary point that he decided right at the beginning, that as there is a general principle of full recovery in this system of law, he ought to be slow to cut that down. There are circumstances where, much as the lordships debated in Marex, there are circumstances where there will be, obviously, claims for both shareholders and companies. And interestingly, Marex touches upon a case which on the facts is very similar to this. The Barings and Coopers and Lybrand case was a case decided in England in the 80s, I think it was, where there was a auditor who had contracted with a parent company for the audit of a subsidiary company. And the claim was then brought by the parent company under contract. And one of the arguments run by the auditors in its defense was, well, I was auditing the subsidiary company, so it's the subsidiary company which has suffered a loss. Now, Barings is a case which is overruled and remains, I think, bad law in England following Marex, but it's obviously exactly the same question as before your lordships. What happens when you have a parent company and a subsidiary company, with the parent company having the contract with the auditor, but the auditor carrying out the audit for the subsidiary? Patently, both those entities have a cause of action. The question is, what should the court do to ensure that those cause of actions don't result in double recovery? And in England, further, for general public policy reasons, how should the company's own management and controls be permitted to be impacted as little as possible by the fact of those possible claims? Now, what he's saying in Lebanon, the judge in Lebanon, is you have this principle where both of them can sue. In fact, that is true even in common law situations. So that is something you ought to be slow to disregard in extending this principle that he's identified at 139. Roman 3, there exists in Lebanese law a principle of full reparation for loss suffered due to the fault of another, as provided for in Article 134. That, again, was one of his general principles that he identified right at the beginning and which Maitre Batar accepted. So these are base principles of Lebanese law: full compensation, existence of a claim, and so on. So, and then 4, which is the point I think Millennium Friend put some weight on or criticised, it was open to the shareholders to bring claims for their personal losses, but they've chosen not to sue. Now, with respect to Ms. Day, she focused an awful lot in the final five words, but not very much on the first dozen words. Really, what the judge is saying here is anybody else, in principle, given the general tenets of Lebanese law, could also bring their claims. The claimants, the 21% shareholders or whatever they are in no special position. Anybody else could equally bring such a claim. That's all he's saying here. Now, he says they've chosen not to sue the other shareholders, but that is a bit of a throwaway line. Now, the criticism is, well, there's no evidence for that. But frankly, imagine if the other shareholders had chosen to sue. All you would have is another case with some other claimants against these auditors. The difficulty isn't they have chosen not to sue. The point is there are other shareholders that could bring other claims. The judge isn't putting into his ratio in this case. It's not part of his line of thinking that other shareholders haven't sued. The only point he's making is the company hasn't sued. 5, the limitation period for the claimant's claim is unaffected by the claimant's bringing their claim in the light of LCB not bringing its own claim. The only point he's making here, this isn't really a point specifically about limitation. His point is that there's no prejudice which would be caused by anybody else by his permitting the shareholders to bring this sort of claim. There is no justifiable logical reason why, if he were to allow this claim to proceed, that would prejudice anybody else. The limitation periods, he says, are the same. They're unaffected. So it's not going to do any violence to the rights of other parties for him to cap this principle, to limit this principle to the situations where the company might sue. 6, justice does not require that the viability of a shareholder's claim for the diminution in value of his or her shares must be established once and for all at the time the limitation period began. Now, this was simply, I think, answering an argument which had been put before him below, that everything had to be decided ab initio because otherwise it would leave a great deal of uncertainty. and he's simply saying that that's not right. Why do you need to decide it at the beginning? You can decide it at the end. And he's bolstered in this by Major Mattar's acceptance that there are procedural processes in place, or procedures which the Lebanese court could draw upon to ensure that double recovery didn't obtain. He's simply saying that's not something that needs to be established once and for all at the beginning. It's something that could be dealt with later or at any point. And then 7, it would be a grave denial of justice not to allow the claimants to bring their claim in circumstances where there's no risk to the defence of double indemnification. I mean, with respect to the judge, that strikes me, if I might say, as not much, adding not much more to the first point he made. What he's really saying here, as I read it, is if there's no risk of double compensation, then I shouldn't limit the claimant's rights, given that that is the purpose of the rule in the first place. The next 3 paragraphs are all obiter, because he's basically saying in the next 3 paragraphs, if I'm wrong about that, I'd better consider the position of auditors. So if you stopped at 148, you would reach the conclusion based on this judgment that in circumstances where the company has declined to sue or is not going to sue, or is incapable of suing, there will be no restriction on the general right that a party has, a shareholder has, to bring a claim against a company's auditors, whether under Article 178 or otherwise. He's talking about it at the highest level of generality. But 149 to 151 simply address the point effectively if he is wrong. So he's saying, well, if I'm wrong that Rule 2 is not predicated on the risk of, if he's wrong that Rule 2 is predicated on the risk of double recovery, so if Rule 2 isn't predicated on the risk of double recovery, then he'd accept that Rule 2 doesn't have any application against auditors. So if you go back to 139, what he's saying is that rule that he's set out in Roman 2, which talks about shareholders damaged across the board by a management default, cannot be extended to circumstances where the shareholders are damaged across the board by an auditor default. And the premise of that, and I accept this is only an inference, the premise of that was because he did hear argument and evidence from Professor Slim that said, in this regard, you should limit this rule because another rationale for it is to avoid those positions of conflict. And obviously, the directors of a company are in a special relationship to the company insofar as they will, ex hypothesis, be those in control of the company. And that is why Article 168 and 169 deal with the position of the ut singuli derivative claim if the company declines to bring it. Because, as we all know, there may be circumstances where the company does not bring its claim for wrongs suffered to it by a director, precisely because the directors are those who are in the driving seat. And so the judge is recognising in 149, based on Professor Slim's evidence, that logic does not run to auditors because auditors don't control the company. So there's no real risk of conflict. I accept that's an inference, but that must, in my submission, be the only possible basis on which the judge has said that is obiter comment in 149. At 150, he refers back to I think it must be the preceding 2 paragraphs, he means 148 and 149, and says it's strictly unnecessary to determine whether the Rule 1 applies in relation to auditors. But he goes on to say that he thinks it probably does. But, and my friend said repeatedly, I'm not appealing that, and I'm not, and I don't intend to do. The point is that the Rule 1, which is stated in 139 as relating to management default, he accepts, because of the principle which underpins it, ought to be extended to circumstances where the loss is suffered by a company due to auditor default. And he is accepting that because, under the principle of double compensation, that might still arise under in a claim against an auditor. So in my submission, when you read the judgment carefully from start to finish on this point, not only is it coherent, it is forceful and persuasive on all of these points, and it builds upon all the materials which were put before the judge, and he does the exercise of carefully identifying not just the rule, but the rationale for the rule and the scope of the rule. It is just wrong to say that he imposed the minority thinking in Mareks. If he had done that, just to be clear, he'd have said, there's no principle at all here, and anybody can sue anybody, and you'll just have to work it out in the long run. He wouldn't have accepted the principle in paragraph 139 at all, because Lord Sales wouldn't under English law. So that is just wrong. All the judge was saying when he referred to Mareks and Lord Sales was that he thought it was a useful treatise about the higher principles of company law there addressed. And with respect to his lordship, Justice Field, I would agree. It is an interesting treatise on those topics. The only final point I want to say, subject to anything Mr. Osmond tells me, is that I think in a slightly throwaway line, my learned friend said, well, you can read the absence of reference to the point being, sorry, let me start again. Obviously, the judge limited the scope of the principle he found to situations where there was a risk that the company might bring a claim on the basis that there would then be a risk of double recovery. That principle, that logic, doesn't come through in any of the cases which he cited or any of the scholarly learning that he cited, with the possible exception of the Nassif treatise. And what my learned friend said about that is, well, you would have thought it would have been identified because it's quite important. But you can't say, obviously, it is there because it isn't. And everyone accepted that it isn't there. So the question that the judge had to decide was, what is the ambit of the rule when there is no learning upon it? And he did that, as I say, by reference to principle. My learned friend would have had him say, well, given that nobody has said anything about this before, there must be not only no rule, but the rule I have discerned must be a universal rule that extends even to the situation where there's no risk of double recovery. Now, that would have been illogical in circumstances where, in fact, the judge has identified the rationale for the rule and thought about it, then thought about whether it ought to apply in situations where the company is not going to bring a claim at all. So, in fact, his logic was a lot more sophisticated than the one that my own friend suggests he ought to have employed, because he went back and tried to identify the rationale for the rule before looking at the scope of it. My lords, will you just give me 1 second to make sure Mr. Osman isn't going to tell me I've forgotten something? Unless I can assist your lordships, I think those are all my submissions in answer to this application.
Thank you very much, Mr. Thompson. Any questions from the judges? No questions. Ms. Day, you want to respond to that?
I do, please. I think that's actually going to be a helpful way of showing to you where the judge went wrong, because Mr. Thompson has just gone wrong again in the same way. So I hope I can use that to just explain clearly where the judge went wrong. If you go back to paragraph 19, where he discusses the two rules.
990 or 19?
1919.
Yeah, okay.
Principle 1 and Principle 2. And as Mr. Thompson has correctly said, the judge accepted our Principle 1 and rejected Principle 2. Do you see that? Principle 2 is the principle of shareholder equality and provides that where, due to a breach of duty, a loss suffered by the company, which affects all shareholders, such as a diminution in the value of the shares, the claim for that loss must be brought by or on behalf of the company. Do you see that? Now, one of the things Mr. Thompson didn't do is take you to the 2017 Beirut case, but that principle is established in that case, and I'll take you back to show it. And that is in fact, the key reason the judge went wrong, he was obviously aware of that case and he applies it. But that case says in terms that where there is a loss suffered by the company which affects all shareholders, you bring that by way of derivative action. So the judge was completely wrong to reject principle 2. And when he comes on to say there's no judgment on it, that's wrong. So let me make that good. I should also say, if you look at paragraph 20 whilst we're there, because it was also submitted to you, these are the words used: no one in England thinks the rule against double recovery is the reason for the rule against reflective loss. The judge certainly thinks that's what Lord S.A.L thinks. If you look at paragraph 20, the judge in paragraph 20 was saying that our arguments were very similar to those that feature in the judgment in Marex. And then he sets out the view of the majority. He then refers to the judgment of Lord S.A.L, who held that in such a case, the damage to the shareholder is separate from that done to the company and can be sued for by the shareholder without any problem of potential double recovery being resolved by the use of procedural rules available to the court. So you will see that his decision is foreshadowed there by reference to Marex and the judgment of Lord S.A.L. And I do say that unfortunately affects and clouds his thinking and means that he applies Lord S.A.L's view rather than the view of the Lebanese courts.
Ms. Day,
And
there's
the key,
one thing that's bothering me. If the court and we are deciding what the Lebanese law is, why is Marex relevant? Marex is not a Lebanese case.
No, I agree.
So
Absolutely.
why are we even bothering me? why are we going too much on Marex? To me, Marex is not important.
No, I
Maybe you do
agree.
a comparison, a thing, but
No, I agree. I think what happened was that the parties referred to Marex in passing, almost to say that Marex reflects that every legal system has to have a rule for dealing with this issue. But the judge was absolutely fascinated by Marex, and as I've shown you in the transcript, wanted to talk about Marex a lot. But I agree. In my submission, the judge shouldn't have referred to Marex in the judgment at all, and it's very telling that he did, and indeed that what he says in this paragraph is that and just read the words because they're really important. It leads to his confusion later on. The damage to the shareholder is separate from that done to the company. Then the shareholder can sue. Any problem of potential double recovery is resolved by the use of procedural rules available to the court. That's exactly his decision. It's taken from how he views the judgment of S.A.L in Marex. And with respect, it isn't the law of Lebanon, and I'm going to show you why. Because under Lebanese law, the value of the shareholding is seen not as separate damage, and this is very important. It's not separate damage. It's damage that affects all the shareholders. So it's a corporate damage. It's not an individual damage. And that's where the judge goes wrong. And then if we go back to principle 2 applies. The judge actually finds it applies himself in paragraph 139. But then because he confuses himself to say this is individual damage, he then goes on a tangent to deal with Marex. So if we go forward, I just want to show you that the judge referred quite extensively to the 2017 case because it was very important. First of all, it's at paragraph 74. And you will see there he's reciting what's set out in that case. And if you look about 5 or 6 lines from the bottom, he says the court held that when damages general affecting the whole company and sustained by all the shareholders, the lawsuit is considered a company corporate lawsuit and has to be brought by the company. However, when damage is individually sustained by a shareholder affecting only his or her shares, not sustained by the company as a whole, the lawsuit is individual. Now, my point is that the first part of that is principle 2. So the judge was completely wrong to reject principle 2 because under Lebanese law, principle 2 applies. Then if we go on, the judge mentions this case again at 96 to 98. And at 97, he repeats the same old facts and what it establishes. Then at 98, he refers to Professor Slim, who sought to say it confuses individual claims with derivative claims. With respect, that's simply wrong. I'll take you to the judgment again. The judgment's very clear. The type of loss claimed in this case is a corporate claim. It's not a personal claim under Lebanese law. And then if we go forward, we see he refers to it again in paragraph 134. It's footnote 28. So you will see it's clear the aforesaid principle is part of principle 1. Another strand of principle 1 advanced by the defendants in reliance on Mr. Mattel's evidence is the view expressed in some scholarly writings and jurisprudence. And then he recites the TOUCHE University, TOUCHE singularly. But he's confused himself because actually, as I've shown you, this case proves principle 2. This case says exactly what he recites in paragraph 19 was principle 2, which is where you have damage suffered by all the shareholders, that has to be brought by way of derivative claim. So he's got himself completely confused with respect.
So if you say he's made the right statement in 19, in paragraph 19, but as he goes along, he lost.
Paragraph 19 is a recitation of our submissions. So paragraph 19 is, this is what the defendant said was principle 2. And then what he says later on is, I reject that. That's not a principle of Lebanese law. What we say is he is wrong. And again, Mr. Thompson made the same incorrect submission to you that there's no Lebanese law to support that. That's wrong. That decision, the decision supports it. And even worse, in other bits of his decision,
can you
he recites that decision.
Can you go back to that decision again?
I can. I just want to take you to 139 because in 139 he again refers to it. So although Professor Slim had expressed some concerns about this judgment, actually the judge refers to it in 139 and says this is Lebanese law. So that decision was attached to Mr. Mattar's report. And I'm going to take you to the text of Mattar's report and then to the judgment, because there's a very useful summary of what it represents, which in effect the judge accepted, but then didn't apply because he wanted to get to the Marex result. It's bundle 5C, it's 2163 in the hard copy. Sorry, I'm afraid I don't have the, someone will just give me the electronic copy, but it's paragraph 1.24 of Mr. Mattar. Because it's a very simple principle under Lebanese law, in some ways far simpler than the common law.
What is it? 02?
02, sorry, I'm just waiting for someone to give me. It's 2163 in the
2163.
PDF.
Okay.
Yeah, it won't, I don't think that will be the page though electronically. Sorry.
So 02?
Yeah, it's 02-2243.
2243, okay. Okay, thank you.
And this is where he's discussing this case. And at 1.24, he says in bold, the key point, and this is the key point the judge missed, is that if damage is suffered by the company and all the shareholders, it must be brought by way of a corporate action. Whereas if the damage is individual, i.e. distinct from the damage suffered by the company, affecting only one or some of the shareholders, the claim can then be brought by individual shareholders. So the point here is that this is damage which affects all the shareholders. It's suffered by the company and the general body of shareholders. It's not individual damage. And once you understand that, this claim can only be brought by way of derivative action.
But this is the opinion of Meta.
Yes, no, that's the opinion. But then let me take you to the decision, which I took you to already. Yeah, absolutely.
Bechara, is it?
Bechara, yeah, it's 2414 in the PDF. Let me just get the, bear with me. It's 02-24, sorry, 250. Well, it starts at 2421.
421. Okay.
And then I think we were referring later on to 2450, but let me just check. 2500. Let's go to 2500. It's 2420 in the.
Okay, 2500. Yeah, we've gone through this before.
We have, but I want to just go through it in more detail because it's quite clear that it's just not understood by the claimants or the judge. 2420, the second paragraph from the bottom says, whereas if the shareholder brings a liability action, it should be established whether he institutes the corporate action or whether he brings his individual action in order to deduce the legal consequences. Do you have that? And then, so what the court has to decide under Lebanese law is this a corporate action or is it an individual action? The answer here is established that this is a corporate action because this issue about shareholdings affects all of the shareholders. And this is where the judge goes completely wrong because he goes back into being a common law lawyer and doesn't decide the questions in the order that he should.
I think it is influenced by the Supreme Court decision. Yeah, okay, go on.
Then if we turn over the page, we have the two paragraphs I've already taken you to. And these are cited by the judge. He accepts this is the Lebanese law. So the distinction between corporate action and individual is the nature of the claimed damage. So you ask yourself, is this a loss that affects all the shareholders? If it is, it's a corporate action. If it only affects some of them, then it's an individual. And then obviously on the facts, same as our facts, it's general damage. So it's a corporate action. So applying this case is also a corporate action. And then we read on. Article 168 of the Code of Commerce provides that the right to bring the action belongs to the company. And if the company fails to exercise it, then every shareholder will be entitled to bring an action on behalf of the company to the extent of that shareholder's interest in the company. And therefore, what you do is you bring it by way of derivative action. Therefore,
go on.
And then it carries on, whereas it is clear from the above mentioned Article 168 of the Code of Commerce that the shareholder may not bring the corporate action except in the case of failure and neglect of the company to do the same. So the point is that Lebanese law has expressly dealt with the situation where a corporate claim is not brought by the company. And the answer is that where it's a corporate claim, which this is, as I've just shown you, then you bring it by way of derivative action. What you cannot do is bring it as an individual claim, because this is not individual damage. That's Lebanese law. It's actually very simple, and it wasn't applied here. And then the next paragraph says the file of the present case reveals that the plaintiff didn't produce any proof of the fact that the company had failed to bring the corporate action. So again, that's just the point. Proof is important. It's not really decisive, because the key problem here is this is an individual claim. It's not a derivative action. And it's a claim that must be brought in the name of the company, with the claimants then producing proof that the company has failed to bring the corporate action, so they are therefore bringing the corporate action on behalf of the company. And then we see in the next paragraph, the court dismissed the claim. So this is very simple and very straightforward, and that's what the judge should have applied. But he didn't go on to do that, because he then went back into notions of Marex. It's very, with respect to him, it's quite hard to follow his reasoning. And we see that at 148, the first sentence, there has been no decision on whether a shareholder or group of shareholders can sue a wrongdoer who's caused damage to them and to the company when the company has declined to sue or is incapable of suing. That's actually wrong. We've just seen in the case that that was considered. So that's a manifest error on the face of the judgment. What we don't see, and what I'd understood that originally to mean, was that this was a situation, in other words, there was no decision on the point that Professor Slim was seeking to adopt. But the way in which Mr. Thompson put it was much wider than that. It was that there was literally no decision on that issue. Of course there is, and the judge has cited it himself at 139 and earlier in the judgment. That decision also proves that we were correct in relation to principle 2. So, as I say, for those reasons, the judge did go fundamentally wrong here. And what he did was he failed to work out whether this was a corporate action or an individual action under Lebanese law. And if he'd done that, he then would have led himself to the 2017 judgment. But he forgot that these are different principles to those under the common law. I then should also deal with Mr. Thompson's point about whether or not this applies to auditors. 149 doesn't help Mr. Thompson, because what the judge says in 149, he says, I accept Slim's evidence that Rule 2 has no application in claims by shareholders for, and these words are very important, personal individual loss brought against the auditors. So what he was saying is, where you have an individual claim for individual damage, that doesn't apply to auditors. But what he says at 151 is that it does apply to auditors where it's a corporate claim. Because Rule 1, that's when you go back to 139, and he actually refers to the Bashara case. So you read 139 and 151 together. So the judge has found that Bashara applies to auditors. And as I say, because the judge was so confused, and at 149, he's approving something that Slim said in relation to individual damage. But this isn't individual loss. This is corporate loss under Lebanese law. There is a remedy. It's a derivative action, but that is not how this claim is brought. It's also a derivative action where the claimants would have to plead and prove that the company had refused to bring the claim. So those are my submissions, and I would urge you to overturn this part of the decision if it's necessary. In other words, if you allow the appeal on limitation.
Okay, thank you very much. Any questions from the judges? No? Okay, Mr.
My Lord,
Mr. Thomas.
I didn't want to interrupt Miss Day, but there was quite a lot of what she said that wasn't in reply. And there is one point in particular that I just wanted to respond to, if you'll indulge me for 2 minutes.
Yeah, sure. We'll hear you. We'll hear you.
So my learned friend addressed what she said was a failure by the judge to find that Principle 2 was proven. But with respect, although she took you to the Bechara Tuma decision and Matta's report, she didn't identify where the judge's thinking on that fell. So can you look, please, at what she just showed you, which is page 2163 of the PDF, Matta's report, paragraph 1.24, that is 02-2243, 02-2243. And my learned friend took you to the paragraph in bold there to say, and she showed you the judgment, and she said this is a clear opinion of Maitre Matta on Principle 2, and the judge didn't accept it. Compare, if you will, that paragraph in bold to paragraph 139 of the judgment Roman 2. It's actually this point. 139 in the judgment at 139.
Richard Field's judgment.
Yes. In that judgment, you may recall he identified two principles which he had found, or two rules. Yes. And the second one is this: where all the shareholders are damaged across the board by a management default, the claim for a management fault against the directors must be brought as a corporate claim at university or a derivative claim ut singuli. Now that is what Maitre Matta is saying in 124. 124 says the key point is that if damage is suffered by the company and all the shareholders, it must be brought by way of a corporate action in the name of the company, whereas the damage is individual, as distinct from damage suffered by the company or the general bodies of shareholders affecting any one or some of the shareholders, the claim can be brought by individual shareholders. So that is in Principle 2. This point, which is also the one decided in Tuma, is the one that the judge accepted. The Principle 2 was the idea that shareholder equality demands some different approach. That is the principle that the judge said was made up at the last minute and wasn't found in the cases. This principle that you've just been shown in the last 10 minutes was one that the judge accepted. So again, I'm sorry to say, but Ms. Thompson,
let's get the facts straight. Do you accept that this action should have been taken by the corporate, not the individual shareholders? Do you accept that?
No.
Why not? Why not? The damage is caused to the company. The damage is not caused to the company, to all the shareholders.
The damage has been caused to the company, and there has damage also been caused to the shareholders. They are causally connected, but they are different.
Because every time the damage is caused to the company, it will flow down to the shareholders. No doubt about that. But this is not an instance where damage is not caused to the company, but caused to the individual. Say, for example, the example given just now, a fraud committed by one person who's supposed to be holding for Shams one particular shareholder. Then there is the right of that individual shareholder. But here we accept that because of the facts of the case, the damage is caused to the company. If you accept that. You don't accept that, my lord.
With respect, we don't accept that, and it's wrong in principle anyway. With respect to your lordship, because it is evident, as I think Justice French was debating with Ms. Day earlier, it is evident that there can be, in principle, circumstances where there is a loss suffered to the value of the shares, which is connected to, but not in any way the same as the loss suffered by the company. So the classic example is where a company is defrauded, but it manages to recoup all the monies that were stolen from it. But nevertheless, shareholders in the market think, well, if that company can be defrauded, I don't think it's very trustworthy, so the value of the shares go down, even though the value of the company does not. Now, that's the classic principled example. We say in this case, You have to start from the principle that it is only the shareholder that's bringing the claim. We do not accept, and contrary to what my friend says, it is not pleaded, that our loss is nothing more or less than the company's loss. We say our loss is the loss in the value of the shareholding. That is separate and distinct from the company's loss. It may well be, and this is the point I think my friend is making, that all the other shareholders would have suffered a like loss because all the shareholders would have been in the same boat as we were. And so the point that Metra Matar is making at 124 is that if damage is suffered by the company and all the shareholders, it should be brought by way of corporate action in the name of the company. That is the principle 2 at 139 of the judge's judgment, which he effectively accepts, but he says it cannot be extended to the circumstance where the company itself is not going to bring the claim. That's the point. What was rejected by the judge is the idea of principle 2, which he found was lately invented by the defendants after the initial report of Metra Matar and not in the cases. And that principle is that somehow the idea that shareholders are all to be treated equally, as of course one would expect in a solvent company and indeed an insolvent company, that principle also required that claims could only be brought in a derivative action. That is the principle 2, as the defendants called it, which the judge said didn't exist. The principle that my learned friend's taking you to, he accepted it exists, but the key point which my learned friend didn't even address in reply is that the judge said these principles exist though they do, ought not to be extended to the special circumstance where the company is not going to bring the claim. That's the critical point, and the judge was utterly clear on that. And although my learned friend likes to tell you time and time again that the judge went off on a frolic of his own and just didn't accept her principles, in fact, he did accept the core of her principles. He just said they didn't apply in circumstances where the company wasn't going to bring the claim. And that, in my submission, was entirely principled and as I've explained, understandable given he'd worked out the rationale for the rules.
Okay, thank you very much.
Sorry,
very much.
I'm just, my client's expressing concern. Can I just reply very briefly, because yesterday, obviously, the right of reply shouldn't be a tit for tat. Can I just very briefly say, I'm sure you have the point, because you can read paragraph 19. You can read paragraph 19, you can read paragraph 139, you can read the 2017 decision. And Mr. Thompson just made a key concession, which this, under Lebanese law, the only question you ask yourself is this a loss that affects all the shareholders? That's the same point in 19 and 139. If it affects all the shareholders, only a derivative claim, and you can only bring the derivative claim on presenting proof that the company isn't bringing it. But that's been dealt with. But I just, you'll understand how important this case is for the clients. And I think those listening feel that there's a lot of time being given.
For myself,
rules not being followed.
I understand the basis of Mr. Thompson's submission. I understand clearly the basis of Ms. Day's submission. It's just for me to decide which is the right decision or the decision that I will make. That's all. Mr. Justice Shamlan, any question? No? Just French, no questions? Okay. Okay. With that, thank you very much to Mr. Thompson and Ms. Day. I think we have to reserve our judgment. We'll come back with the decision later, So for now, I say thank you very much. Your submissions, I think, has made the authorities, the submission very clear, make it easier to write, hopefully easier to come to a decision. To the judges, can we go on to the judges link? We'll discuss something about this case. Okay, thank you very much. And
thank you.
Good night to me and good afternoon to you all.